Is it too late to do a Cook Islands trust after you've been sued? The answer is it's not too late, but it could be less effective in the sense that a creditor is going to bring, or likely to bring, a fraudulent conveyance action to collect a judgment, arguing that the trust was set up to evade collection of the judgment. And almost all, I don't say all states, I think all states, but maybe one that isn't, have statutes allowing courts to reverse transfers that were done with the intent to avoid creditors. There are so-called uniform fraudulent conveyance laws that most states adopted that allow them to reverse such transfers. So, once even a lawsuit, once a claim prior to a lawsuit is in play, that a transfer to an offshore trust is subject to attack as a fraudulent conveyance. Now, it's not a fraudulent conveyance to set up an offshore trust. It is a fraudulent conveyance to transfer assets into the trust. So there's no penalty for setting up the trust. The penalty, or the risk, not the penalty, the risk is that the certain transfers could be attacked as fraudulent conveyances and then subject to reversal. In most states, not all, but most states, there is no additional penalty for a fraudulent conveyance into a trust. So the judgment will not be increased. You're not going to go to jail in most states, but the transfer would be attacked and the creditor would try to reverse it. Now, that doesn't mean that there's no benefit to you, because even if you transfer assets into the offshore trust after a claim has been asserted, and let's say that the U.S. court issues an order stating that the conveyance to this offshore trust was intended to avoid creditors, the creditor still has to enforce that order. And if there is a finding of fraudulent transfer, the order would be served on the offshore trustee, or attempted to be served on the offshore trustee, getting the trustee to convey back the assets. Problem for the creditor is that the offshore trustee is not subject to the court jurisdiction of the U.S. court and may just ignore the order. In which case there's a order stating that the trustee received assets as a transferee as part of a fraudulent conveyance and is ordered to reverse it, but he just decides not to comply. Under the statutes, if a recipient of an asset does not comply with the order, the creditor's other remedy is to get a judgment against the recipient for the value of the asset. So that if you, for example, conveyed $100,000 of stock to an offshore trustee, the trustee refuses to return it, then the creditor gets a judgment for $100,000 against the offshore trustee. But again, what good does that do him? Because the creditor is not going to be able to enforce the judgment against the offshore trustee. So to that extent, in theory, that you could still use an offshore trust and do conveyances, to the offshore trust after a claim or judgment has arisen. In theory, but in practice, it's not that simple, because even though the offshore trust may have enabled you to protect the asset from legal process and have put the asset outside the reach of the U.S. court, including fraudulent conveyance, you're still going to do damage to yourself in the U.S. court jurisdiction, because frankly, you're going to make the judge very angry that you've taken such blatant steps to evade the rulings of the U.S. court and the judgments issued by the U.S. court. And even though the judge may not be able to directly impose a fraudulent transfer remedy on the trustee, the judge is going to be then disposed to rule against you in all other matters before the court. And you've essentially poisoned your stance in front of a U.S. judge because you have taken such blatant action to avoid the U.S. court judgment well into the claim or the litigation. And again, even though they may not directly be able to impose a fraudulent transfer remedy, in all subsequent matters before the judge, the court is probably likely to be disposed to rule against you and try to sort of get back at you and your attorney for doing this in the face of what would a likely U.S. court judgment. So I guess the answer is you can set up an offshore trust after the fact or after a claim has arisen, but make sure you and your attorney consider the practical consequences of doing so at this stage of the proceeding in all other matters before the court.